are the benefits of mediation, if any? My name is Akiva Goldman. I'm the director and founder of Goldman & Associates. Our firm has a primary focus on family law issues here in Michigan, and today we're going to continue our video series designed to educate and inform the public, so please subscribe to our channel. What are the benefits of mediation? You know, a lot of times the court will order you into mediation. You wouldn't even have a choice. So benefits or no benefits, you're going to mediation. You have to understand that it's not the most efficient way to run your family of having some third party in a black robe tell you shall do this and you shall do that, okay? So ultimately, while you may not think that's great, the court also doesn't think it's so great, and that's why the court will often order things to mediation. The court would like the parties to get it resolved so that the judge doesn't have to make that call. Remember one thing, even if you do so begrudgingly, if you settle your case on your terms, maybe you give a little more than you should, maybe you take a little less than you should, whatever. If you settle it on your terms, even begrudgingly, it may be still better for you than take the chance on telling the judge, hey, you figure it out, and then the judge will tell you, you shall do this and you shall do that. You may not like the way the court divvies things up, and I'll tell you something from many, many years of experience. Judges have a beautiful knack, an uncanny ability to make both sides miserable. Go figure that. But believe me, they can do that. So therefore, it might behoove you to use a mediator. And in fact, the court realizes that this is the case, and the court may order you into mediation. And the benefits are like this. Number one, well, you might get it resolved. And you might get it resolved quicker. Sometimes the parties don't trust each other. The wife doesn't trust the recommendation of husband's lawyer. Husband doesn't trust recommendations of wife's lawyer. So now there's not only trust between the parties, there's a lack of trust between the lawyers. So they need yet a third lawyer. And the third lawyer will say, this is reasonable, this is not. This is what the judge will probably do anyway, so you might as well go along with it. The judge will never go for this. You know, the mediator has that experience. We do it here in the office all the time. We have our lawyers conduct mediations. We are set up to do it here. We have multiple conference rooms for that very purpose. Lawyers who have experience do this all the time. They help out other people in trying to resolve this. Number one. Number two, the cost is a significant savings. The mediator does charge, and that mediation may cost you $3,000 or $4,000, but it's a fraction of what that trial is going to cost you. And if you can spend $3,000 or $4,000 on mediators and avoid the $20,000 cost of trial prep and the trial of getting what will probably be the same anyway, tremendous savings for both parties. Number three, timing. Your mediator can pick a time and probably get it done in a 4-hour session, an 8-hour session, maybe even they go over the next day, or they have to have a second session, whatever. The court sometimes will try a case. Have you ever had the pleasure of trying a case in a family law situation? You know what happens in some courts? The court starts your trial. You go for 2 or 3 hours, and the court says, okay, I have a full docket this afternoon. We can't continue this. We'll give you another date. Guess what? 4 months down the road, come back. We're going to do day 2. Can you imagine this? You know what happens when that occurs? Your lawyer cannot rely on the preparation for day 1 when day 2 is 3 weeks or 3 months away. Your lawyer's got to prepare all over again. Do you realize the costs of the constant preparation, the reissuing of summonses, the re-prepping of witnesses? That's gone every single time as the court tries to squeeze you in between 2 other cases to hear your case. And then, once it's all over, you know what happens? You think the court gives a decision immediately from the bench, so you know what happens? Probably not. In a lot of cases, the court issues a written opinion. And you know what happens? The court can't issue that opinion so quick. It's got to review transcripts from the first day of trial, which was 8 months ago. It could take another 8 months to get that opinion. And then, if the other side doesn't like it, they could take appeal. Do you realize the lack of finality in that situation, not to mention the unbelievable time and cost? A mediator doesn't work that way. A mediator is not an advocate. A mediator finds the middle ground, gets the parties to attempt, if possible, to settle the case, and then right then and there makes a transcript and swears the parties in. The parties approve it, and then somebody can file a motion to enter a judgment consistent with that mediation, and that's it. Case is over. And the judges like to hear those motions and grant those motions. They want the parties to be able to move on with their lives. So when you talk about the advantages of a mediator, I got to tell you, you get the right person, you're going to save yourself a lot of time, a lot of money, a lot of aggravation, and you'll ultimately get it done. And it'll probably be what the court would have done anyway in most circumstances. So I strongly urge the parties to consider mediation as a dispute alternative, especially if they are seeing they can't get along and they're staring down the barrel of a trial. If you have any questions about that, reach out, and we'll be glad to help you out.